Welcome to the lesson on the Global Anti-Corruption Sanctions Regulations 2021. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. The Global Anti-Corruption Sanctions Regulations 2021 mark a significant expansion of the UK's anti-corruption toolkit, reinforcing and extending the reach of the Bribery Act 2010. Established under the Sanctions and Anti-Money Laundering Act 2018, these regulations, often referred to as the Anti-Corruption Sanctions Regime, empower the UK government to impose travel bans and asset freezes on individuals, entities, and organisations suspected of involvement in serious corruption. This regime is distinctive in that it targets individual actors rather than states. Its primary focus is on foreign public officials and those who benefit from or facilitate corrupt activities, especially in jurisdictions where domestic enforcement is weak or compromised. The regulations have already been used to sanction a number of individuals linked to corruption schemes in Russia, South Africa, and other high-risk jurisdictions. By doing so, they extend the UK's capacity to combat corruption beyond the territorial limits of the Bribery Act, while avoiding the diplomatic repercussions typically associated with state-based sanctions. Under the regulations, the term corruption mirrors the framework of the Bribery Act, encompassing both bribery and the misappropriation of property. However, the scope is deliberately limited to conduct by or involving foreign officials. Private sector corruption remains governed by the Bribery Act. This distinction underscores the complementary nature of the two instruments. While the Bribery Act focuses on domestic and commercial integrity, the global anti-corruption sanctions provide a foreign policy mechanism for addressing international corruption with direct links to the UK financial system. Despite their broad potential, the regulations have drawn criticism for failing to define serious corruption, a key threshold concept. This lack of precision has raised concerns about predictability, transparency, and proportionality in the designation process. The accompanying government guidance offers limited clarification, merely stating that designations will align with the long-term objectives of the UK anti-corruption strategy. This leaves considerable discretion in the hands of decision-makers and creates parallels with earlier criticisms of the Bribery Act, particularly regarding the lack of practical guidance for compliance and enforcement. The ambiguity is partly attributable to the novelty and political sensitivity of the regime. Targeting politically exposed individuals, often from powerful states or strategic partners, poses diplomatic and evidential challenges. Consequently, the government has opted for a flexible approach that balances legal certainty with operational discretion. However, this flexibility may undermine the perceived legitimacy of the regime if designations are viewed as politically selective or inconsistent. As of the 4th of November 2025, the regulations are expected to be updated to allow amendments to existing designations and to introduce new listings of individuals implicated in serious corruption. These measures reinforce the UK's commitment to using financial and mobility restrictions as tools of accountability, complementing criminal prosecution under the Bribery Act. In effect, the Global Anti-Corruption Sanctions Regulations 2021 represent the international dimension of the UK's anti-corruption strategy. It can be concluded that while their practical impact depends on clear and consistent implementation, they signal a decisive move towards a more assertive, globally engaged stance against corruption, combining legal enforcement with strategic diplomacy. Thank you for your interest in this topic. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.